The fifth and final step in the E5 trademark system is enforcing your mark, or enforce. Enforcement can be kind of complex, but it really breaks down into possibly 3 actions. Now, sometimes you might skip actions 1 and 2 and move step to action 3, which is litigation, but typically your enforcement process will take 3 distinct steps. Step 1 is notice. That's where you simply make the person or party that is using your mark or something that's confusingly similar to it aware that you actually have a trademark, especially if you have a registered U.S. trademark. The second step is a cease and desist letter. So usually, in my experience, the majority of the time, that you give someone notice and an opportunity to quit using the mark that you already have, they'll stop. But sometimes they don't. And when they don't, you gotta let them know that you're serious. This usually involves the cease and desist letter, which then takes their mark, puts it up next to yours, and makes it crystal clear that, hey, their mark is confusingly similar to yours. And if you have specific examples of somebody being confused, a consumer being confused, you let them know one of your examples. Not always your best, but usually it is going to be your best example that you lead with. Again, because the trademark system, it's not about protecting your mark, it's about protecting the consumer and preventing them from getting confused. So you want to have a cease and desist letter that you're proud to put in front of a judge. And the third action is litigation. Now, not to be too complex here, but by the way, litigation, in case you don't know, means a lawsuit. But sometimes what you'll see some people with trademarks do is they actually will go ahead and file a trademark lawsuit before sending a cease and desist letter, but they don't formally begin it by serving process on the other party. They just go ahead and file it. And this kind of emphasizes again the seriousness of that cease and desist letter. Hey, we've already got a lawsuit filed against you. We're just being nice and haven't sued you yet, formally. But it emphasizes the seriousness of it. But that's not as common. Usually what you'll see is this action sequence of first notice, second a cease and desist letter, and third, and only as a last resort, litigation. And also I'll add this as well. On websites that have specific branding programs like Amazon and Shopify and eBay, there are procedural requirements both within the court system as well as within these specific commercial systems, let's call them, like Amazon. So to navigate all of these, you'll want to give us a call, and then we can help guide you through those so that not only will you have the registration itself, you'll be able to maximize the benefits that you get from it. So if you have any general questions, you can leave them below. But if you have a specific question about your specific situation, call me or another trademark attorney. And I'll see you in the next video.